All right, we're now ready to start the hearings. Nelson Figueroa?
Yes, sir.
Sir, you've got a charge here, possession of cocaine. Your bond is $1,000. Do you want me to appoint a lawyer for you, sir?
I guess so, yeah.
All right. Office of the Public Defender is appointed. That's Division 14.
Can I resolve it today?
No, it's a felony.
Felony. All right, Maggie Keene.
Yes, sir.
Ma'am, you've got a set of charges here. Possession of cocaine with intent to sell or deliver, bond $15,000. Grand theft, third degree of motor vehicle, bond $1,000. Possession of alprazolam, bond $1,000. And possession of paraphernalia, bond $500. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, public defender is hereby appointed, and that is Division 20. Your name, sir?
Jason Aloysius Lennon.
All right, you've got a capias here for failure to appear on burglary and exposure cases, and there is no bond. Have you previously been appointed a lawyer?
I'm sorry, Your Honor. Is this Mr. Lennon that we're?
Yes, ma'am.
Oh,
Thank you, Your Honor.
all right, let's make sure that I understand. The name?
I believe this is Jason Aloysius Lennon.
Yes, ma'am. Yes.
Ja- All right, we'll see if Madam Clerk can find the file. All right, Jason Lennon, right?
Yes, ma'am.
Okay, sir, you've got a set of charges here. Possession of weapon by a convicted felon, bond $5,000. Possession of chemical agent by a convicted felon, bond $5,000. Armed trespass in a conveyance, bond $1,000. And possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defender is appointed, Division 10. All right, Nua Lukash?
Yes, ma'am.
All right, sir, you've got a failure to appear capias. The judge set you in a no bond status. Have you previously appointed? All right, the public defender was previously appointed, Division 11. The next guy's first name is Elderly.
Mr. Parades. The next one will be $5,000. 2 days credit time served. Normal.
AG?
Huh?
AG?
Yes. That's if it's elderly. 5 and 2.
You must be so elderly, it's hard to... All right, elderly Normal.
Yes, mister.
All right, sir, you've got a case here involving an allegation of sitting or lying on sidewalks in downtown Core District. Is there an offer from the state on this?
Yes, Your Honor. It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and court costs.
All right, now, let's see, sir, you've also filed this application for a public defender. Do you want me to appoint a lawyer for you?
I don't know appoint me a lawyer, but I'll take the 5 days.
All right, there's a factual basis stated here. There would be an adjudication, 5 days credit for 2, court costs of $273 payable within 1 year.
Pro se.
All right, the next case is that of Richard Glisson.
3 days, sir. Okay, thank you. Records. When would Mr. Dormo be able to leave on the plea deal? He's in 2 days, so Saturday. So today is Thursday. Good luck, sir.
Your name, sir? Your name?
Richard Marvin Glisson.
All right, Mr. Glisson, sir, you have a case here involving a charge of trespass on property after warning. Your bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, public defender appointed, Division A, offer from the state?
Yes, Your Honor. It's an adjudication, 7 days Orange County Jail, 2 days credit time served, no return to 105 East Robinson Street in Orlando, which is the Insight Credit Union building. Abide by all trespass warnings and court costs.
$323. All right, and for the record, what plea now is entered on this trespass case? I've been handed the plea form, so that has been signed by the accused. Plea is accepted. There would be an adjudication, 7 days Orange County Jail, credit for 2 days, time served. Court costs $323 payable within 1 year. No return to this location at 105 East Robinson Street. Court costs $323. And abide by all trespass warnings. All right, that would be everything then. Antonio Rodriguez.
Yes, sir.
Sir, you've got a Seminole County warrant for violation of probation and grand theft. So you'll be transported to Sanford to take care of the charges there. Lucius Brown. Sir, you've got a case here involving a charge of attempted burglary of a conveyance. Bond is $1,000. Do you want me to appoint a lawyer for you, sir? All right. Office of the Public Defender is appointed, Division 20.
All right. One moment. I apologize. We were missing one of the out counties. All right. There you go, sir. That's the current bond we're dealing with. That's our number. Call us when you can. Good luck.
All right. Your name, sir?
Christopher Curtis.
All right. Sir, you've got a set of charges here. Driving while license suspended or revoked, bond $500. Fleeing or eluding a law enforcement officer with lights and sirens activated. No bond at this time in regard to that charge. And I see no request for appointment of the attorney. Let's see, you've also got a case here involving possession of over 20 grams of cannabis, bond $1,000, and possession of drug-related equipment, bond $100. So there's no request for appointment of counsel here, and so that's all I can tell you right now.
Did you ask for public defenders first? Okay. All right, sir. At the moment, I can't help you, but you're gonna want to get in touch with the DA when you can.
See?
All right.
The fleeing and eluding, is there gonna be a bond?
I thought the bonds were called on the resisting.
The fleeing or attempting to elude a law enforcement officer with lights and sirens active is the one that states no bond.
And Your Honor, if the state may be heard as to bond on that count,
All right?
the state would recommend to the court a bond of $2,500.
All right, instead of no bond, count 2 on this case would be $2,500, and the bond on the other case remains the same.
He qualifies for PTR.
And Your Honor, the state would oppose pretrial release as one of these charges is fleeing and attempting to elude law
Well,
enforcement.
I would agree, and that would be ordered. And let's see, we've got Division 20 in regard to the Dwellis and the fleeing, and Division 17 on the burglary, et cetera. Wait a minute, wait. Is that right? Yes, that's, I misstated that. All right. Then possession of marijuana bond 1,000 and equipment bond 100. Divisions 20 and both are Division 20. All right, next case is that of Damian Guthrie. Is that you, sir?
Yes, sir.
Sir, you've got a case here involving two charges: burglary of a dwelling, bond $5,000, grand theft of more than $100 from a dwelling or curtilage, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir, please.
Office of the Public Defender is appointed, Division 17.
Nothing to do right now. Don't worry about it. That's
All right, Antoinette Jackson,
Yes, sir.
is that you, ma'am?
Yes, sir.
All right, Miss Jackson. Ma'am, you've got a charge here, possession of amphetamine. Bond is $1,000. You want me to appoint a lawyer for you?
Yes, sir. But I was told I could try for a pretrial release.
All right. My question was simply, do you want me to appoint a lawyer, yes or no?
Yes, sir.
Okay.
I'm sorry.
Public Defender appointed, Division 16. All right, your name, please?
Clavy Jones.
Sir, you've got a set of charges here. Carrying concealed firearm by $150. Possession of a firearm by a convicted felon bond $150. Possession of ammunition by a convicted felon bond $5,000. There's no request for a appointment of a lawyer. That's Division 20. All right, next case is that of Igor Milov.
Correct, sir.
All right, sir, you've got, looks like 3 cases here. A failure to appear on a grand theft 3rd degree, no bond, Division 22. Failure to appear on a trespass, no bond, and a failure to appear on resisting an officer with violence, no bond. Do you want me to appoint a lawyer for you, sir?
Yes.
All right, Division 22 on failure to appear on the grand theft, 3rd degree. That's Division 22. Then Division 15 on trespass case, and Division 22 once again on the resisting with violence. Michael Parks. All right. Carlos Paris.
Yes, sir.
Sir, you've got a charge here, retail theft, more than $300. Bond is $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defenders appointed, Division 12. All right, next file is that of Eric Quintana Rivera.
Yes, sir.
All right, sir, a set of charges here. Fleeing or attempting to elude a law enforcement officer with lights and sirens, bond $2,500. Possession of heroin, bond $1,000. Possession of paraphernalia, bond $500. Resisting an officer without violence, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Oh, there's another case here, resisting an officer without violence, bond $500. Public defender appointed, Division 12 on the multiple charges and A on the resisting without. All right, Romaine Davinsky.
Yes, sir.
All right, sir, a set of charges apparently. Carrying a concealed weapon by a convicted felon. Possession of cocaine with intent to sell or deliver with a weapon. And on the first charge there, concealed weapon, no bond. Cocaine case, no bond. Possession of cannabis with intent to sell or deliver with a weapon, no bond. And possession of cannabis more than 20 grams with a weapon, no bond. And possession of cocaine with a weapon, no bond. Possession of ammunition by a convicted felon, bond $5,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right. Public defender is appointed, you qualify. Division 6 on concealed weapon by a convicted felon. Division 10, possession of cocaine with intent to sell with a weapon. Division 15, possession of cannabis with intent to sell with a weapon. And Division 22, possession of cannabis more than 20 grams with a weapon, no bond. And Division 16 with the charge of possession of cocaine with a weapon, no bond. And then lastly, possession of ammunition by a convicted felon, bond $5,000. Now, you have several different divisions. Division 6, 10, 15, 22, and 16, and 19.
Your Honor, may the state be heard as to bond on the matters that are listed as no bond, Your Honor?
Yes.
In 2019 CF 3594AO, possession of cannabis greater than 20 grams with a weapon, the state would recommend a bond of $5,000.
All right, so ordered.
And in 2019 CF 3597AO, carrying a concealed weapon by a convicted felon, the state would recommend a bond of $5,000.
So ordered.
And 2019 CF 3593AO, possession of cocaine with a weapon, the state would recommend a bond of $7,500.
Now, did you say 3595?
3500.
Okay.
Yes, 3593, Your Honor.
Okay. Let me get that.
And in 3595, possession of cannabis with intent to sell and deliver with a weapon, the state again recommends a bond of $7,500.
All right.
And in 3596, possession of cocaine with intent to sell and deliver with a weapon. In this possession of cocaine, the state would recommend a bond of $10,000.
Okay. So ordered.
And the final case already had a bond set, Your Honor.
All right. And the public defender, again, has been appointed. All right, next case is that of Virgil Stevens.
Yes, sir.
Sir, you've got a case here involving failure to appear on driving while license suspended, possession of paraphernalia, and at this time you're in a no bond status, and I have no application for criminal indigent status, so if you may well have a public defender already appointed, but one is, yes, you do. That's Division 15. Your name, sir?
Jose Torna.
All right, Mr. Torner. Sir, you've got 2 counts here. No bond on failure to appear on count 1, delivery of heroin, and count 2, delivery of cannabis. There's no application for criminal indigent status. You were probably already appointed a lawyer. Okay, the public defender already represents you, Division 12.
Wait, hold on. You will get to me against the office on that. I don't have the information at the moment. He's not set in stone right now. But I want to wish you good luck. Right, call us when you can.
All right, your name, sir?
Edward Wilson.
Mr. Wilson, sir, you've got a set of charges here. Purchase of heroin, bond $15,000. Possession of heroin, bond $150. Attempted destruction of evidence, bond $100. Possession of drug paraphernalia, bond $100. Fleeing, attempting to elude a police officer, no bond at the moment. Resisting an officer without violence, bond $100. Do you want me to appoint a lawyer for you, sir?
Yes, Your Honor.
All right, and is there any input from the Office of the State at this time on the fleeing case?
Yes, Your Honor. The state would recommend a subsidiary bond on count 5 at $150.
All right, that seems reasonable. Bond 150 on count 5, fleeing. And, sir, let's see. Did I already ask about a lawyer? Yes. Okay, Public Defenders appointed, Division 22.
All right. Your Honor, just to double check, the first count was 15,000?
Correct. All right, Nicholas Brown.
Yes, sir.
All right, Mr. Brown, you've got a case here involving a charge of panhandling. Your bond is $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
Public defender appointed, offer from the state?
Yes, Your Honor. It's an adjudication of guilt, 4 days, Orange County Jail, 2 days credit time served, and court costs.
That's how much? All right, sir, you don't have to accept that offer. You may, if you want.
I accept.
My client would like to accept the state's offer and enter a plea of no contest.
All right, plea is accepted. Adjudication, 4 days, Orange County Jail, credit for 2, $273 court costs payable within 1 year.
Thank you.
One moment, please sign, make sure everything's in order. Slow writer. Second. That's good luck, sir.
All right, next file is that of Lloyd Salter. Is that you, sir?
Yes, sir.
Sir, you've got a charge of camping, bond $250. You want me to appoint a lawyer?
Yes.
Public defender appointed, offer from the state?
Yes, Your Honor. It's an adjudication of guilt, 5 days, Orange County Jail, 2 days credit time served, and court costs.
273. Ah. All right, sir, please accept it. Adjudication of guilt, 5 days credit for 2, court costs $273, payable within 1 year. Thank you. All right, Michael Springs. Sir, you've got a charge of camping. You want me to appoint a lawyer?
If I need one.
you qualify for the appointment of the public
Okay,
defender. Do you want that appointment?
Yes, I
Public defender's appointed, offer from the state.
It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, and court costs.
crazy. But I ain't got no choice but to take it. I don't understand what this is supposed to teach me.
All right, in regard to this case, then there would be an adjudication upon the written receipt of the plea form. 5 days credit for 2, court costs $273, payable within a year. Your name, please.
Yaritza Cruz.
All right, Ms. Cruz, you've got a set of charges here. Petty theft, bond $250, and then you've got an Osceola County case, violation of probation, and you're in a no bond status as to that. Now, in regard to this Orange County case, do you want me to appoint a lawyer for you?
Yes.
Public defender appointed, Division A. Now, is there any offer from the state on the Orange County case?
As she's on probation for a theft case, no, Your Honor.
All right. Public
No.
defender appointed.
Your Honor, if the defense may be heard.
All right.
My client is going to be dealing with a probation case, I think connected to this matter in another county, Osceola. Would it be possible to release her ROR so she can go to Osceola and deal with that matter before that judge?
All right. State's response?
Your Honor, the state would object. She was on probation for a theft case, has now allegedly committed another theft case. The state would object to release ROR.
All right, let me look here. All right, there is a, on the Osceola County case, that is a grand theft case. The defense request would be denied in that regard. All right, next file is that of Geneva Dixon. Is that you, ma'am?
Yes.
All right. Ma'am, you've got a set of charges. Petty theft with prior convictions, bond $500, and possession of cannabis, bond $100. Do you want me to appoint a lawyer for you on these cases? Did you answer?
I can't hear you.
Do you want me to appoint a lawyer for you?
A lawyer? Yeah. Yes.
All right, Office of the Public Defender is appointed. That's Division A.
If I may ask, records, my client does not qualify for PTR, but the reason is additional notes. Was there a more compiled reason available on your end for the qualification for PTR for my client at this time?
Yes, she refused to provide emergency contact.
Yeah, I'm not even gonna go through that.
Don't worry, ma'am. So these are the bonds we're currently dealing with. Please call us when you can. I want to wish you good luck.
All right, Austin Glatt.
Yes.
Sir, you've got a new charge here, petty theft. You're out on bond on a burg of an occupied structure, et cetera. The bond on which you're released is stayed. The bond on your new case of petty theft is increased to $1,000 from $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
All right. Public Defender appointed, Division A.
So let me just quickly write this down. All right, so your last bond is still good. All you have to worry about is this one. Okay, so you don't want to cause a punishment. I don't think the numbers actually changed much from my notes. 500. So, but again, I want to wish you good luck. Okay? All right, good luck.
All right, your name, please?
Ichala,
Full name.
Ibukunlua, Ayokunumi.
All right. Ma'am, you've got a trespass charge here. You did not, and you're out on bond on trespassing in a structure or conveyance. Now, there's no request for a lawyer. So in regard to the new case, since you're out on bond on the old case, that ROR would be extended on that old case. And the new case, the bond would be $1,000 instead of, no, strike that. It would remain at $500. And no application for criminal indigent status was filed. So at this time, no lawyer appointed.
Yeah, excuse me.
Right, ma'am. Yes. Did you want a public defender assigned here?
No.
Okay.
I mean, my lord, I mean, really, I should not be on the street. You know, I think I do have more than enough money to have a house, to stay inside of the house. I think they're keeping me outside intentionally. I've been outside for 6 years, and it should not be. I can't even get any employment. I'm entitled to, I have every right to have employment. I have every right to have to be inside the house with my children. Yesterday, I was at the tax office,
Let me see.
tax. No, I mean, the tax thingy, she's supposed to actually return my money.
Oh. Your name, please?
Wesley Crochet.
All right, I want to make sure I have the right paperwork here. George Montoya Moran? Is that correct, sir?
No, sir. I got a DOP out of state. I mean,
Sorry, sir. Did I mix up?
All right, sir, your name, please?
George Montoya.
All right, sir. You've got a set of charges here. assault on an officer or firefighter or EMT, bond $500. Resisting an officer without violence, bond $100. Sir, do you want me to appoint a lawyer for you?
Yes, please.
Office of the Public Defender is appointed, Division A. All right, next file is that of Jamina Zelaya. Your name, please?
Jamina Zalia.
All right, ma'am, you've got a charge of trespass after warning. Do you want me to appoint a lawyer for you?
Yes.
Public defender appointed. Offer from the state?
Yes, Your Honor. It being adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, no return to 4117 South Cimarron Boulevard, which is the Avalon condominiums, and abide by all trespass warnings.
Apologies. What was the days to be served?
5
Okay.
with
thank
2.
you. Thank you. My client would like to accept the state's offer and enter a plea of no contest.
All right, there's a factual basis here. The plea would be accepted, adjudication of guilt, 5 days credit for 2, no return to this location at 4117 South Cimarron Boulevard, Orange County, and abide by all trespass warnings.
And Your Honor, the state has one more condition, and that would be no contact with the victim, Miriam Palacio, the owner of the property.
All right, so ordered.
Jamina Zalia.
I can't hear.
Jamina Zalia.
All right, the next file I have is that of Severino Castillo.
He's not, Your Honor.
All right. Reset. Yeah. All right, Wesley Croce?
What's the name, Your Honor?
Wesley Jr. Croce, if I pronounce that correctly.
Crochet, sir.
All right, sir, you've got a Hillsborough County warrant
Yes, sir.
for violation of probation, it looks like. So you'll be transported to Tampa to take care of the charges there, sir.
Okay.
Thank you. Sean Rhines. Say again?
Sure, Devon.
All right. Ooh, $70,000. Alicia Rivers. Is that you, ma'am?
Yes.
Okay. Ms. Rivers, you've got a Seminole County warrant. You're in a no bond status in regard to that. So you'll be transported to Sanford to take care of the charges there, ma'am. All right, the next file I have is that of Mario Aponte. All right, sir, you've got a charge of aggravated assault. Your bond is $2,500 with condition no victim contact. Do you want me to appoint a lawyer for you, sir?
Yes, sir, please.
Public defender is appointed, and says here Division EAB.
16.
16? 16.
He's on the take any action on it?
No. No action taken on the bond on which he's released.
One moment. Okay, you're good on this last one. So all I need to worry about is this bond. Okay? Call us when you can. This is an ongoing. I want to wish you good luck.
Next file I have is that of Paul Clark.
Mental health, Your Honor.
All right. Yesterday was mental health also. I'm appointing the Office of the Public Defender to represent Mr. Clark. It was an open container.
You want to keep his bond, or you want to reset, or what we do?
Reset. All right, Candy Glenn.
Yes.
Ma'am, you've got a charge here, introduction of contraband into county facility, bond $1,000 at this time. Do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is hereby appointed. And I assume there's no offer from the state?
No, Your Honor, that is a felony matter.
All right, Division 20.
Just.
Then have Wayne Malier.
Your Honor, just to seek clarification on my client, Ms. Glenn, we're just here for the 3556AO case, the introduction to contraband, right?
Yes. Yes, sir.
Okay, one moment. Let me give her the paperwork. Apologies. Okay, ma'am, that's the bond for this case. Call it. Yeah, so I want to wish you good luck.
All right, Wayne Malier.
Yes, he is. You don't worry about it.
All right, sir, your name, please.
I don't have a name.
You don't have a name.
No, I don't.
All right. Huh.
So why am I here?
Well, I've got a Wayne Malier case. Input from counsel in regard to this unusual situation with a no-name defendant.
Your Honor, as Mr. Malier, Mr. AKA No Name, has been brought out under Wayne Malier, and I believe that possibly prints have confirmed his identity.
Well, in an abundance of caution, what I'm going to do, let's see, we got heroin, count one, $1,000 bond, fentanyl, bond 150. I'm going to appoint the Office of the Public Defender to represent this individual with no name.
Well, how about I represent the,
Action on
Hmm?
those? You gonna take any action on 2D? I don't know.
All right, the bonds in regard to 2019-2264 and 2018-17860 are revoked.
Oh, sorry, one more.
I'm not a party to these transactions. That name is private property, it belongs to me. I'm hereby seizing that name. You want to use it, get my express
There you go.
permission.
Have the paperwork. Paperwork. Okay.
And I apologize, Your Honor, on Mr. Malier, where the bonds stayed in 3502.
No.
Yes.
Thank
Oh,
you.
okay. All right, the next file I have is that of Justin Upton. Your name, sir?
Justin Kenneth Upton.
Mr. Upton, sir, you've got a charge here, a retail theft, more than $300. Bond is $1,000 at this time. Sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, Office of the Public Defender is hereby appointed, and for a division number on this new case, it has TWY 14.
We probably gotta do the motions first, 'cause those people involved.
Oh,
Apologies, Your Honor. A moment to prepare my paperwork and possibly
is,
prepare my
this
paperwork.
guy?
One moment.
I don't know who.
all right. Now, for clarification here, what is the name of the individual before the court at this time?
Luis Arturo Benavides Hernández. Luis Arturo Benavides Hernández.
This is Mr. Benavides Lewis.
Oh, oh,
A moment, Your Honor.
They're there. Let me see. Judge. I think there's a. It should be him.
all right.
Apologies, Your Honor. We are here today on a motion for release on own recognizance for my client today, Luis Arturo Benavides. I would like to swear in my client to, my client is currently unable to pay his bond and has been found indigent by the court. He was assigned a public defender because of that. I would like to swear him in to ask him some questions so that the court may be enlightened to his current predicament.
Please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right.
Your Honor, before we proceed, may the state be heard. The state has no objection to this motion, Your Honor.
All right, and any recommendation as to, ROR, right?
Yes, Your Honor. It would be, the
All
state
right.
would ask for an ROR with, just an ROR, Your Honor.
All
This
right.
was a resisting without violence.
Then, so ordered.
Okay, you're good. Apologies, Your Honor. If I may confer briefly with state, apologies. Yes. Your Honor, with respect to my current client, Miss Caitlin Deanne Murray, the public defender would at this time like to withdraw her motion pending further review of her case.
All right.
He wants to withdraw the motion.
Motion withdrawn. Your name, please?
Aaron Torres.
All right, State have any input?
Your Honor, if the state may just ask pretrial services if there are any prior failures to appear and what the conviction history is.
We have no failure to appear, no misdemeanors, no felonies, no Florida conviction history. He have arrest history, petty theft, trespass, out of state convictions. He have burglary 3 times 3, misdemeanor larceny, possession of heroin, possession of Schedule 1 heroin, breaking it, entering. Out of state arrest, he have trafficking, DV, particular order violation ×3, possession of stolen motor vehicle, obtained property, false pretense.
At this time, Your Honor, the state would ask that defense proceed with their hearing.
Certainly. Your Honor, we are here today for my client, Mr. Efrain Torres, seeking a non-monetary release. Simply put, my client has been found indigent, which is why the public the public defender's services were rendered to him. I would like to swear him in so that he can help enlighten the court as to his current predicament, and of course to assist in this plea.
All right.
Please raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. Mr. Torres, I have to ask, are you able to pay the premiums on your current bond?
Not at the moment, no.
All right. And Mr. Torres, do you have any source of income at this time?
No, not at the moment.
Okay. And do you have anything you think you can sell? Anything you can pawn off?
No, no, sir.
All right. I would like judicial notice to be taken that the court has accepted an affidavit of insolvency in this case. The accused is therefore presumed to be indigent and without financial resources. So if such notice may be noted, I would continue in my questioning of my client. And Mr. Torres, do you have family in the area of Orlando?
Yes, I do. I have a grandmother and a father that lives in Buffalo.
All right. Did you reach out to your family in the area to ask you for assistance with the bond?
I didn't bother because they're both on fixed incomes, collect disability.
Okay. Now, sir, have you ever gotten into any trouble in Florida before this case came up?
No, sir.
All right. Now, Mr. Torres, I need to ask a couple questions. If you're released on without having to pay bond, would you swear to attend all future court dates?
Yes, most definitely.
All right. Would you have a place to stay in the local area?
Yes, I do.
All right. And would you appear for, all right, do you have a means by which to get to every single court date?
Yes, I do.
What are those means, Mr. Torres?
I plan on working at a temp agency as soon as I get out of here, raising some type of funds and being able to take the bus, the transit system here in Orlando.
All right, now, Mr. Torres, I need to ask you, what are you going to do if you are released without having to pay bond?
I will seek employment at a temp agency, returning to society, being as productive a member as I possibly can, and attending all my future court dates, and just getting this behind me, paying fines, fees, and spending time with my grandmother. That's she's getting up in age, and that's basically it. Getting this behind me.
All right. I have concluded the questioning of my client at this time, Your Honor. If the state had any questions?
Yes, the state does. Mr. Torres, good morning.
Good morning, ma'am.
Mr. Torres, you said, in response to your counsel's questions, you said that at this moment, you cannot afford bond.
No, ma'am, I can't. I don't
Okay.
have any money.
You qualified it with not at this moment, is that correct?
Yes, ma'am.
Have you called a bondsman?
No, I haven't bothered because I don't have any money to pay one.
Okay, so you have not bothered to call a bondsman. What is the amount of your bond?
$500.
And Mr. Torres, what is your understanding of what you would have to come up with for that bond?
I'm uncertain of that.
Okay.
From what I hear, 10%, but you have to have a co-signer and.
Okay. All right. And Mr. Torres, you did not reach out to any bondsman, correct?
No, ma'am.
And you said that you did not reach out to your family. I believe you said your grandmother, correct?
My father.
And
Yes,
your
ma'am.
father, correct?
Yes, ma'am.
And you said that was because they're both on fixed incomes.
Yes, they
Is
both
that
collect
correct?
disability.
But you did not reach out and ask your grandmother if she could assist you. Is that correct?
No, ma'am, just for the simple fact that she's like up in her age
And
she's
I
old.
appreciate the explanation.
Yes, ma'am.
But is it correct that you did not reach out to your grandmother?
And partly because of that, I can't remember the phone number to call her.
Okay. And is it correct that you did not reach out to your father?
That's correct as well.
Okay. So you did not reach out to the bondsman, your grandmother, or your father?
No, ma'am.
And you're going to reside with your grandmother and your grandfather, and your father?
Yes, ma'am.
In Orlando here?
Yes, ma'am.
And your counsel's motion states that you are self-employed in the vinyl siding business,
Yes, ma'am.
and that you intend on continuing that employment if you're released.
If possible, yes, ma'am.
Okay. And when you said that you have no means of income at this moment, were you working before you were arrested?
Yes and no. I was doing vinyl siding when there was work.
Okay. When is the last time that you had a siding job?
Less than 3 months ago.
About 3 months ago?
Yes, ma'am.
And do you get paid per job, per hour? How do you get paid?
Weekly.
You get paid weekly?
Yes, ma'am.
And since you're self-employed, is that you paying yourself?
No, I mean, I was working with the crew, but it was more or less under the table when I was working more recently. So I just consider that self-employed.
Okay, okay, so you were actually working for a company?
Yeah.
Okay.
As of recently.
But you got paid weekly when there were jobs?
Yes, ma'am.
Okay. I have no further questions. Thank you, sir.
All right, anything further from defense?
No further questions for my client, only arguments. Your Honor, my client came to Florida, as the facts will show, to get a fresh start. he came here and got into some trouble. I believe the case number is 2019 MM00136680. However, he has been found indigent by the court. He is unable to pay. Keeping him here when he is, of course, willing to attend all future court dates is, I think, against the pursuit of justice. Any person, as per Rule 3.131A, any person charged with a crime which is neither a capital offense nor a crime punishable life imprisonment. Apologies, one moment. Okay, so the imposition of a money bond on an individual already declared by the court indigent is, I find, unreasonable. Well, my client is already willing to attend all future court dates. He has connections to the community, and he is, of course, willing, and he is going to become a more productive citizen if allowed out to work. Simply put, I would like to end my argument by saying that I believe it would be in the best interest of the community if my client were allowed to reintegrate as court date was pending.
Say,
Yes, Your Honor. This, number one, is a victim crime, and there are damages to a unrelated, independent victim in this matter. And that victim did not have an opportunity to be present today to provide their input because this matter went on the docket yesterday afternoon and the state was not able to contact the victim to get them here today. Having said that, there has been no testimony put on the record to show that there has been a change in circumstances since the time that the bond was set in this matter. And also, based on Mr. Torres's testimony, he has not made any attempts to see what his portion of the bond would be. He has made no attempts to see if he can get assistance in obtaining a bond. The motion states that he is self-employed. His testimony states that he does work in vinyl siding, and he testified that he will seek employment on a temporary basis once released. The state would ask the court to deny his motion in part and modify his bond according to what the state is seeing. And if I may just make certain that I'm looking at the correct minutes here, Your Honor. Okay. The state would have no objection to a modification in the bond. However, because there has been no change in circumstances, he has made no attempts to see if he can come up with the $500 bond. The state would ask the court to deny the motion in part and modify his bond to $250 with a standing order of no return to the scene of the crime.
all right, defense.
Here, defense would argue only that the facts of the case show that the incident for which he was brought in Florida, there were mitigating circumstances. Apparently, one of the involved persons attempted to falsely imprison his vehicle, which thus led to the escalation, which resulted in the resulting damage, Your Honor. If my client cannot be allowed out ROR, however, considering these mitigating circumstances, would a further reduction of the bond be possible?
All right. Well, the court, under the circumstances here presented, would modify the bond to $200 with a condition, no return to the location of the alleged offense.
And Your Honor, if the state may, that would be the area of Belvedere Road and Lynbrook Road in Bithlo, Florida.
All right. All right, next file I have is that of Leroy Royal IV, case, don't have it. Oh, here we are. Case ending number 419.
Your Honor, this time the state's going to need a moment just to switch over to that docket, if I may.
All right.
Thank you.
You're going to be here tomorrow. You're my favorite. Gee whiz, that's not nice. It's going good. It's going good. I just don't see my. I apologize, Your Honor. I'm having a little bit of a technical difficulty here. Thank you, Your Honor. The state's ready. All right. So, Leroy Royal. All right, if council would please announce their names for the record.
Good morning. Edith Bush for the Office of the State Attorney, second session.
Fernando Pardes of the Office of the Public Defender.
All right. Now, the first file I have is that of Billy Robinson. Is that you, sir?
Yes, sir.
All right, sir. You've got a case here involving a charge of trespass on property after warning. Do you want me to appoint a lawyer for you, sir?
I like the public defender.
Public defenders are lawyers.
Oh, yes, sir.
The Office of the Public Defender is hereby appointed, an offer from the state.
Yes, Your Honor. The offer is an adjudication of guilt, 10 days Orange County Jail, 3 days credit time served, no return to the scene, which is the Wawa at 4100 East Colonial Drive, abide by all trespass warnings, and court costs.
My client would like to accept the state's offer and enter a plea of no contest.
All right, there's a factual basis stated here. So the plea would be accepted by the court. There would be an adjudication, 10 days, credit for 3 days, time served in the Orange County Jail, no return to this location at 4100 East Colonial Drive, the Wawa, as I understand it, and abide by all trespass warnings, if any, and court costs $323 payable within 1 year.
Good luck, sir.
So I get out 10 days?
7.
All right, Danny Dutty?
Doty, sir.
All right, sir, you've got a case here involving trespass after warning in a conveyance. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public defenders appointed, CRA division, offer from the state.
Yes, Your Honor. It's an adjudication of guilt, 7 days Orange County Jail, 4 days credit time served. No return to the Burlington Coat Factory at 8204 South Orange Blossom Trail, and abide by all trespass warnings and court costs.
What would the court cost be?
I'm not taking that.
Sorry, hold on, if I may. If the defense may be heard, Mr. Doughty doesn't seem to have a very extensive criminal history. Would a possible credit time served be possible considering his,
I just had surgery.
considering that he is in a currently a less than optimal condition to be in jail under?
All right, I note that this case was reset because the accused was in the hospital yesterday, it would seem. No, the 11th.
On Monday, Your Honor.
Yes. So,
And, Your Honor, may the state be heard as to the rationale behind the state's.
Yes.
The state's offer, which was formulated on the 11th, is based not only on the facts in the case, but also on his Florida conviction history, which includes trespass ×4, and some of those trespasses were at the same Wawa. Disorderly intox, petty theft ×3, and various violations of ordinances. He also has an extensive out-of-state conviction history as well. And that is what factored into the 7 days that the state is offering at this time.
And if the defense will may be heard, whilst I admit that Mr. Doughty does have a history, I did not say he did not. I would also say that he has just gotten out of surgery. He's a former military veteran. I don't think the cause of justice would be furthered by keeping my client in jail for 3 more days, considering his condition.
I was beat up and robbed. I had to sit down.
Apologies. All right. It would be 3 more days, or about 3 more days. All right. I know you're in a bad state, so.
All right, and, sir?
Yes,
I would
sir.
inquire as to, is that a bandage on your chest or a name tag?
I was
Okay.
beat
All
up and
right.
robbed, sir. I got a bandage on my back.
Okay. All right.
I would, at this point, request clarification from the bench. Would a possible plea to the bench result in a credit time served for my client? I'm only asking because of his current condition, not on any merits of the case.
All right, in the event a plea of guilty or no contest is entered, there would be an adjudication and a total of 5 days, credit for 4 days, time served, no return to this location at 8204 South Orange Blossom Trail. Abide by all trespass warnings, and court costs payable $323 within a period of 1 year.
I'm blind. Right here. Go on today, right, man? Okay.
Okay, sir, I need to ask, are you on probation anywhere?
No.
Okay, good, then you're safe.
The next file I have is that of Kern Blount. Is that you, sir?
Yes, sir.
All right, sir. You have a new case involving grand theft, 3rd degree of a motor vehicle. Your bond was set at $2,500. You are presently out on bond on drug charges, 2 drug charges. That bond at this time would be revoked. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender appointed, Division 12 on the new case.
But your last bond has been revoked, sir. Okay, I'll leave the public defender transfer, and I want to wish you good, right?
All right, Garen Collins. Is that you, sir?
Yes, yes.
All right, Mr. Collins, you've got a failure to appear capious, 2 counts, attempted burglary of a conveyance, resisting an officer without violence. The judge in that case set you in a no bond status. There's no financial affidavit filed. So at this time, no attorney would be appointed. If there's one already appointed, that would stand, and that's Division 12.
You already have a public defender assigned to your case, that's good. 1 moment. Let me give you on
All right, next file is that of Harold Horn.
He's in the hospital, Your Honor.
All right, reset. All right, next cases are Timothy Hogue.
Yes, sir.
All right, sir, you've got a new case here involving grand theft, third degree of a motor vehicle. Bond on that case is $1,000, and then burglary of an occupied structure. No bond as to that case. The bond on which you're released, which is another grand theft, third degree of a motor vehicle, is revoked. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
All right, and I'm appointing the public defender, but you also have a case of possession of methamphetamine, bond $1,000. Public defender is appointed, and we have Division 19 on the grand theft case and 15 on the drug case.
And Your Honor, may the state be heard as to count 2 in 2019 CF 3618 AO as to bond.
All right, hold on just a second. All right, say again as far as the request.
The state would like to be heard as to bond as to count 2, burglary of an occupied structure.
All right,
The state would recommend a bond of $7,500 and request the court order no return to the scene.
all right, so ordered as to that, so you could be released on posting the bond, sir, and no return.
Your Honor, if I may, if the defense may inquire, would the judge be willing to allow the out on bond to stand with the understanding that one of the other charges could be doubled?
All right, state's response to that request.
Your Honor, as this is a similar type crime as the one that he was out on bond on, the state would ask the court to stay the revocation.
All right,
and no bond.
the court's prior decision on that case looks like the grand theft third degree on which he's already released, that request would be denied. That bond would be revoked.
Your Honor. All right, sir. You're currently having your last honor vote. You can't bond out yet. Call our number when you call this.
All right, next file is that of Terry Lee Hudson. Is that you, sir?
Yes, sir.
Sir, you have a set of charges here. Burglary of an occupied structure, bond $5,000. Petty theft, bond $100. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Public defenders appointed, Division 17. All right, your name, please?
Amanda Lynn Kitteman.
All right, ma'am, you've got a new set of charges. Carjacking, bond is no bond at this time. Aggravated battery with a deadly weapon, bond $150. Grand theft third degree of a motor vehicle, bond $150. Grand theft third degree more than 300, less than $5,000, bond $150. there's a factual basis, and you're out on a couple of bonds here, dealing in stolen property, scheme to defraud, and possession of cocaine, et cetera. And those bonds, each of them would be revoked. Now, do you want me to appoint a lawyer for you?
Yes, please.
Well, let's see. Yes, here it is. Public defender is hereby appointed, and looks like Division 12 in each of these new cases.
Your Honor, did we go over the cases of 3620 AO and 3236 AO for my client's bond status?
All right, let me look here. All right, what was the case number of that? Okay.
The first one is 2019 CF 3236. The carjacking was the bond stayed at 0.
Yes.
All right, got it. 0. All right. That will be it for the moment.
Yes, it was.
Oh, yeah.
He already called. I thought he did. I thought he called all three.
I thought I did.
Yeah.
All right. What I think is a repeat here. Grand theft, third degree of a motor vehicle, new case, allegedly committed today. Grand theft, third degree of motor vehicle, bond 1,000, and then possession of methamphetamine, new case today, and that is $1,000, and the Office of the Public Defender is appointed. Next file I have is that of Sharon Mack. All right. Joanna Murphy. Jonathan Nieves de Jesus.
Yes.
All right, sir. A case involving an allegation of possession of cocaine, and the bond on that is $1,000. Now, there was a capias issued, no bond, for failure to appear in court. Now, do you want me to appoint a lawyer for you?
Yes.
All right. Public defenders appointed, Division 10. And 81 on the FTA if none has been appointed. All right, Alberto Rodriguez,
Yes.
that's you, sir. Sir, you've got a set of charges here. Armed robbery with a weapon, bond $10,000. Criminal mischief, bond $150. Now, there would be a condition also added to the robbery allegation, $10,000, and possess no weapons or firearms. And, sir, do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed, and that's Division 14.
And Your Honor, the state would also request a no return to the scene, the eye smoke outlet, and no contact with any witnesses or victim.
All right, that would seemingly be appropriate. That's ordered also. All right, next file is that of Joan Shea Smith. Is that you, ma'am?
Yes.
All right, ma'am, you've got a charge of possession of cocaine. Bond is $1,000. Do you want me to appoint a lawyer for you?
Yes.
Public defender is appointed. Division 11. All right, next file is that of Terrell Green. All right. Then the next file is that of Kelvin Aguilar. Is that you, sir?
Yes, sir.
All right, sir, you are released on a petty theft bond. That bond is stayed. You have a new case involving a charge of trespass on property after warning. Do you want me to appoint a lawyer for you on that new case?
Yes, sir.
Public defender's appointed, CRA. Is there an offer from the state on the new case?
Yes, Your Honor. It'd be an adjudication of guilt, 10 days, and 2 days credit time served, no return to the Wawa at 7030 South Orange Blossom Trail. Abide by all trespass warnings and court costs.
If defense may inquire of the state, I know my...
Oh, excuse me. I didn't go read far enough here. Mr. Aguilar does not qualify for appointment of the office of the public defender. So that announcement, if made, is hereby revoked. All right, so sir, you can, Mr. Aguilar, you can enter a guilty plea to that new charge. If you do, you'd be adjudicated guilty, sentenced to 10 days with credit for 2 days time served, so you'd have 8 more days. No return to the Wawa there at 7030 South Orange Blossom Trail. And court costs 300. Okay, $273 payable within 1 year, and abide by all trespass warnings if any others exist. So, do you want to accept that?
Yes, sir.
All right. There is a factual basis stated here, so the plea would be accepted on the new case. There would be an adjudication, 10 days, credit for 2 days, time served. No return to this location as previously described. Abide by all trespass warnings. Pay court costs in the amount of $273 within 1 year.
Thank you.
Yes, sir. All right, next case is that of Tashia McLean.
Bonded.
All right. Deron Michael?
Yes, sir.
All right, sir, you've got an Osceola County warrant, and your bonds total $15,500. You can post bond here. If not, you'll be transported to Kissimmee to answer to the charges there. All right. And the next file I have is that of Luis Valero. All right. All right, anything else from council?
Nothing further from the state, Your Honor.
Nothing further from the defense, Your Honor.
All right, then we're in recess, subject to call, actually.